I'm going to be talking to you about the eligibility criteria in the Voluntary Assisted Dying Act. If you look at the section, that's what it looks like, and I'm not asking you to read that on the screen, it's far too small. But as the old joke goes, if you want to eat an elephant, the best way to do it is in very small chunks. And so I'm going to break it down for you. And I would just like to say I've always hated that joke, so I'm not sure why I'm telling it to you, because who would want to eat a beautiful creature like an elephant? But here we go. So I'm going to set out the criteria that need to be satisfied if you want to access voluntary assisted dying. The first one is pretty straightforward. You have to be 18 years of age or more. And that is, of course, the age in which you become an adult. You can vote, you can marry, you can go to war. And now, from about June or July next year, you will be able to make your own choice about dying a dignified death. So that's, as I say, it's straightforward. The next criterion is about status and residency. And if you look at this provision, it also looks fairly straightforward. But in fact, we inherited that from the Victorian legislation, and it was quite problematic in Victoria. When Steve and I went to a conference earlier this year in Melbourne, Dr. Rodney Syme was there. Many of you will have heard of him. And he was quite distressed that in the early days, there were about 6 people, which was quite a high proportion of the number we were talking about, who were not able to access the law because they couldn't prove that they were either an Australian citizen or a permanent resident, and perhaps they couldn't prove that they'd been resident in Victoria for the 12-month period. This is, of course, to stop what is called by our opponents death tourism. And so that's why these provisions are in the Act, because they weren't going to get through without them. So I think that it's the doctors, the 2 assessing doctors, who have to make a decision about whether or not you are eligible for assisted dying. And we are hoping, Richard Luck, our doctor on the committee, is particularly hoping that we're going to be pragmatic about it. But at this time, we haven't got the guidelines from the Department of Health. They will be published before the Act becomes operative next year. But until then, we can only give you our best guess and our best suggestions. And so what Richard thinks is that in most cases, a Medicare card will suffice. And if there's any problem with that, then of course the normal things like a passport, a citizenship certificate, a birth certificate showing that you were born in Australia will put that matter beyond doubt in little one. For the ordinary residency requirement, again, a Medicare card, a medical record, evidence that you live in Western Australia, a lease, a rates bill, some agency. And so the reason it's important to talk about these things now is that if and when the time comes and you are suffering, you're dying, you don't want to be scrabbling around looking for your passport, which you've lost. And so it's really important just that you have a documents folder somewhere, you can put these documents there, you can be satisfied that you will satisfy these criteria, and then you can just forget about it and hope that you never need it for this purpose again. The medical condition. This is obviously fundamental to what qualifies you to ask for help to die. What little 1 and little 2 boil down to is that you must have a terminal illness, and that terminal illness must be likely to end in your death within 6 months or within 12 months if you've got a neurodegenerative disease. So that's the medical part of it. That is for the doctors to assess. But of course, prognosis is a very inexact science. And if they get it wrong, if you have in the meantime gone through the process, you have qualified, you have opted for self-administration, and Steve will talk more about the difference between self-administration and practitioner administration. If you've opted for self-administration and you have the lethal substance, they're not going to take it away from you. And if you happen to live longer, well, that's fabulous so long as you're not suffering. And for many people, it's very comforting to know that if things get really, really bad, then they have a way out. The last of these requirements, that it's causing suffering that cannot be relieved in a manner acceptable to the person, or tolerable to the person, that the person considers tolerable, that is a purely subjective test. And so no doctor can come and tell you that you're not suffering enough to access this law. It's for you to decide. If the doctor says to you, well, look, we can give you loads and loads of morphine and that will cure your pain, you can say, no, thank you. I want to be conscious toward the end of my life. I want to be able to interact with my family members. That is not acceptable to me, and I refuse it. And just as an aside, even without this law, without voluntary assisted dying legislation, the right of self-determination gives all of us the right to refuse any treatment if we want to. And we can refuse food and hydration. And indeed, before this law was passed, many people would have been driven to take one of those alternatives in order to bring their life to an end. And so, and I, for instance, for religious reasons, could say, I don't want a blood transfusion, even if it were obvious that that were going to save my life. And so that right of self-determination exists alongside voluntary assisted dying. But this is specifically about if you are suffering and it cannot be alleviated in a way that's acceptable to you. Capacity is interesting. The person has to have decision-making capacity in relation to voluntary assisted dying. And those last few words are particularly important because capacity changes depending on what you're talking about. So you may not have the mental capacity, in fact, most of us don't, to understand a complicated legal document or to sign a will. But for the purposes of voluntary assisted dying, there are very specific requirements about that, and those are to be found in section 6, if any of you are interested in going into the minutiae. And it requires that you understand the concept of voluntary assisted dying. So essentially what we're doing today, you need to understand what it entails, what the eligibility criteria are, what the process is. You don't have to understand every one of the sections in 101 pages of legislation or whatever it is. So you also have to have an understanding of the advice and information that is provided to you on the subject by your medical practitioners. You thirdly have to understand the consequences, obviously, that if you are provided with a lethal substance, it will cause your death. And this is also a really good thing in this particular provision, that you don't have to prove that you have mental capacity. There will be a presumption that you have capacity unless there's evidence to the contrary. And so obviously the doctors will talk to you and reach their own assessment. And if they are in any doubt about whether you have the required capacity, then they are required to make a referral to somebody with the relevant skills and knowledge to make that assessment. The person has to be acting voluntarily and without coercion. And the safeguards in relation to this are built into the Act. So it's within the process. There are 3 requests that have to be made, and Steve will cover that. But the second one in particular is a written declaration that says, I know what I'm doing, and I'm doing it without any form of pressure on me or duress. And that gets witnessed and so on. There are also 2 independent doctors who have to be satisfied that you are acting completely of your own volition, and it is indeed your life, your choice. And again, if either of the doctors is in any doubt about this, then they have to refer to another person to get an independent assessment of this particular aspect. And something I think that is overlooked by our opponents when they say, well, sometimes you can't detect it, and one of the doctors may be under the influence of the family members who want you to die and they want to get their hands on your inheritance and all that stuff. There are really severe criminal penalties for a breach of any part of the Act, but this one in particular carries a jail sentence of 7 years for anybody who, by dishonesty or undue influence, tries to persuade you to request or access voluntary assisted dying, and it's life imprisonment if they try and induce you to take the voluntary assisted dying substance. So there are not many doctors who would risk not only losing their practicing certificate and their livelihoods, but would also like to spend the rest of their lives in jail. The next criterion is that the request for access to voluntary assisted dying has to be enduring. And what is meant by that is that at every stage of the process, you have to have capacity and you have to continue to affirm that this is what you want. Of course, once you've got the substance, then it's up to you when and if you take it. But if there's going to be practitioner administration, and again, I don't want to cover Steve's ground, but the doctor will ask you to affirm at that time that you understand what you're asking for and if you still want to go ahead. Because you are, of course, entitled to withdraw from the process at any time, and that will bring everything to an end. And if you then later have second thoughts and say, well, actually, I do want to access it, then you do have to go back to the beginning and start with the first request again. And this comes to the last criterion, which is about mental illness and disability. It's really important that mental illness or disability will never of itself give you access to voluntary assisted dying. But if you satisfy all the other criteria that we've been through, then neither will having a mental illness or disability prevent you from having access to voluntary assisted dying. And that includes all the safeguards that are built into the Act to ensure that this is not abused in any way. And as you can imagine, in Parliament, this was debated quite heatedly. There were people who thought, well, vulnerable people will be pressured into it, they'll be taken advantage of, the next thing will be killing babies, etc. But all of the safeguards in the Act apply to this. And once again, the very stringent legal consequences of any breach of trying to persuade somebody to access voluntary assisted dying when it's not actually what they want will result in very long prison sentences, possibly life. And that's it from me. So I will hand back to Kerry to introduce Steve, and thank you very much. And then we'll
Okay, so I'm here to talk about the process. Now, the Act itself, has many more provisions regarding requirements than just Section 16, but we've selected this as the principal source, I suppose, of the rules, or at least a summary source of the rules as to who can access voluntary assisted dying. The statute, the Act, is not that hard to read, by the way, although non-lawyers always find that acts are far longer than they expect them to be, and wonder, as Murray does every day of the week, why this sort of thing can't be done in a two-pager, but it's not. And I must say, as an overall comment, that the Act we ended up with, although it's not perfect from our point of view, is a very good Act, and it has several, at least three, really significant improvements over the Victorian Act, upon which in many ways it's modelled. And the Victorian Act, in its turn, in many ways is modelled on the Oregon legislation, which has been enforced now for 22 years and has been replicated in about 10 other American states. So there are some common central features of all of those schemes, but there are some improvements, I think, in our scheme. Now, you see on the slide in front of you what the essential criteria are for a person to access voluntary assisted dying, and it does sound a bit bureaucratic, but it makes sense when you see the scheme and when you follow through in the following provisions after Section 15, which amplify these things. You start to see how it works. So there has to be a first request. We have to start somewhere. The journey commences with the first step, and here it is, the first request. Okay, how and to whom may it be made? It can does not need to be in writing, as I'm starting to say, and normally it won't be. it would be an oral request, and to whom should it be made? Answer, a doctor. Now, not every doctor is able to participate in this scheme. First of all, doctors to be eligible to participate need to be either a specialist holding a specialist qualification or registration and having held that for a year at least, or otherwise a general practitioner holding general registration and having been so registered for 10 years, which in my personal opinion is far too long, but that's the period they selected, and in fact it's longer than the Victorian requirement. But interestingly, as Richard tells us, many GPs in fact hold a specialist registration although as a general practitioner. Now, so they have to be registered in one of those ways and have had that requisite level of experience. As well, they need to have done the training, which is yet to unfold, but it will not be particularly extensive or onerous training. I think it'll be undoubtedly modelled on the Victorian experience, which they went through in the last year or two, and probably most or all of it will be able to be accessed online, especially bearing in mind country practitioners, but they must have done the training. The important question, being the second dot point, is who may initiate a conversation about VAD. This is one of the respects in which our legislation is far better than Victoria. In Victoria, many may know that there's a prohibition, a complete prohibition against medical practitioners or other people indeed initiating a conversation about VAD, which Victorian doctors will tell you and common sense would confirm is a bizarre and ridiculous provision, which seems to rest upon the unstated premise that doctors, some anyway of them, will have an unstated agenda in which they want to see as many of their patients as possible die as quickly as possible, which is absolutely ridiculous. In fact, the tendency will be the other way, that they'll want to keep their patients alive as long as possible. Victoria is the only jurisdiction in the world where there is such a prohibition. It doesn't exist in the US. Fortunately, we sidestepped that one here in WA. I think there was an attempt in the upper house, I can't quite recall at the moment, to introduce an amendment. There were many amendments moved in the upper house by opponents, and lots of behind the scenes discussions as well, and certainly this was the subject of some of those discussions. But fortunately, those behind the Act, remembering it was a conscience vote in the Parliament, so it wasn't really a party political exercise. Nevertheless, the government, in a sense, was driving it, certainly the Premier and the Minister for Health, who did an excellent job, and they held the line, thankfully. There is nonetheless a prohibition in WA against non-registered health practitioners from initiating a conversation about VAD, and health practitioners may raise the topic, initiate a conversation only in the context of a medical consultation. That was inserted as an amendment in the upper house. So the idea there is if doctors are at a dinner party, Carmel, note this, they should be wary of someone asking them for advice about VAD or indeed gallbladder surgery. Change the topic, talk about the football. No one wants a casual conversation which is alleged then by someone to be a first request and so on and so forth. So it has to be in the course of a medical consultation, and as well, the practitioner must lay out all of the other options available to a patient, which is a fair balance, I think. So they have to advise them about palliative care and treatments available for the condition and all of that kind of thing. So there are some limits or boundaries to how and when this can be done. So you must have been assessed as eligible by, one, the coordinating practitioner, and two, the consulting practitioner. Bureaucratic terms, I guess, but who are they? They effectively, you make a request to a doctor who qualifies, who's entitled to decline to assist you on conscientious objection grounds or indeed for any other reason, it's not obligatory for them to do anything, but they do have to provide you with some prescribed information. We don't know yet what that will be, but maybe information directing you to the care navigators who are going to be important in linking patients looking for doctors with doctors who are willing to participate and who have done the training. So they can decline to assist at any stage. If it's for conscientious objection reasons, I might add, they have to inform you immediately, and that's appropriate so that you can get on with your business and go elsewhere. If they decline to assist for any other reason, including perhaps they're not eligible or they've changed their mind or something, or they're too busy, then they must advise you within 2 working days. But the process commences when you've made that request. A record is made by the doctor and it'll be sent to the voluntary assisted dying board that's going to be created to oversee the scheme. So we've talked about, can they refuse to assess you? Yes, they can. How do you find that doctor who will help you? We hope and think that based on the Victorian experience, you'll be able to get these care navigators. There will be 2 appointed initially at least. They'll be based in Perth. I did speak with someone on what's called the implementation leadership team, as did Richard, about the selection criteria and what have you for these care navigators. The person who runs it will be required to be a nurse. The second one, I think from memory, doesn't have to be a nurse. I think Richard's agreeing there, and there will be at least 2 of those. They started with 2 in Victoria, and I think they've now moved to 4. WA, of course, is probably, 30 times or more the size of Victoria. There may be difficulties. We've spoken about that with the implementation leadership people because there might be some circumstances you would think where a simple phone call from Halls Creek or Laverton or Esperance might not be enough. Might a care navigator have to get on a plane at some point and go out there? We'll see. In Victoria, they started rather late in the process, I would add, and they had to catch up really with the demand once the scheme kicked in. And particularly what they did in Victoria, for reasons that I'll never know, is the list of doctors who had done the training and thus were eligible, and broadly anyway were eligible to participate, was kept private. It was considered to be private, and it wasn't conveyed to the navigators, which is bizarre. So they weren't allowed to know who's in the pool of doctors who are available and willing. And so what was discovered pretty quickly is that people in country Victoria especially were having a lot of trouble. Another huge difference between Victoria and WA, I might add, is in Victoria there's a requirement for one of the 2 doctors to have special expertise and knowledge in the condition which is going to lead to death, and that's interpreted by the bureaucrats there as meaning you have to be a specialist. It's a whole other topic. It's debatable whether they're correct about that interpretation. That's the way it's interpreted. And so people in country Victoria were having lots of trouble in some cases getting a specialist who was A, willing, and B, qualified to participate. And if they were really unwell, which by definition they're likely to be, how could they find a specialist whom they could have contact with, and logistically could they see them? How could they see them? Fortunately, that problem was overcome in the end, and the list has been published. But in the meantime, in Victoria, what happened is that Dying with Dignity Victoria, and particularly Rodney Syme, made themselves available informally because they were getting lots and lots of requests from people for help. And of course, it's urgent, almost always it's urgent. So they became informal navigators, and I understand that now they cooperate very nicely with the formal navigators. Will there be some hiccup like that here? We don't know, we hope not. But that's broadly the way the scheme will operate. So the person has to be assessed as eligible by the coordinating practitioner and the consulting practitioner. Now, the first doctor with whom you've successfully made contact and has taken on the role has to obviously assess whether you meet the criteria. If he or she does, then he or she must refer to a second a medical practitioner who will, if they take on the role, and they have the same capacity to decline to do it if they want, but they'll become the consulting practitioner, and they have to be independent from the first doctor. They have to assess the eligibility for themselves, and they become the consulting practitioner. And then there comes, and by the way, if either the coordinating doctor, the first one, or the consulting practitioner, the second one, has any doubts about, and this is in the Act, has any doubts about whether the person's eligible for one reason or another, for example, do they have 6 months or less, or in the case of neurodegenerative conditions, 12 months or less until death. If they're not sure about that, they have to refer to someone else, another medical practitioner who would probably be a specialist. If they're not sure, for example, about capacity, mental capacity, they can refer to anyone, any other person. That's an improvement from memory over Victoria too, because it's not limited to psychologists, for example, or psychiatrists. And it was suggested in Parliament, somewhat to my amusement, that, you know, a doctor who's unsure about the capacity of a person might even refer to a police officer. And I like most police officers I meet, but I'm not sure what expertise they have in determining capacity. But maybe if you're in Halls Creek, you're not going to get anyone else. So that happens, or can happen, if there's any doubt along the way. And when that other person, be it a psychologist, the local sergeant, or a specialist, comes back with the advice, then the practitioner who's referred off will take that advice on board and be satisfied or not satisfied about the criteria. Then there comes the written declaration, and you know, the Act requires it to be in writing. That's the only step that has to be in writing. There will be, I'm sure, a form that's prescribed. And as with the first assessment by this doctor, the second assessment by this one, forms have to be filled in and they have to be submitted, which will be electronically, to the Voluntary Assisted Dying Board as a record. The coordinating practitioner then, after the final request, these two doctors do their jobs. If all the lights are green, then you make the written declaration and you make a final request to the first doctor, the coordinating practitioner. And this is really obviously just to confirm that this is an enduring wish. You still want to go ahead because the person has the ability, naturally, you'd expect it, to withdraw at any time if they want to. But if they're determined to proceed, they make the final request. And the Act also speaks of timelines, and there has to be, from memory, at least 9 days that the process will take, unless the two doctors are of the view that the person's likely to die in a shorter time, in which case they can truncate it. Otherwise, it would be at least 9 days, but it's likely to take, well, it takes as long as the patient wants it to take, and in many cases it may take a bit longer than that. So the coordinating practitioner, having got the final request, and he or she has got the written declaration as well, will certify in a final review form that everything's been done, the process has been completed. The practitioner is satisfied of various matters set out in that subsection, and then the person has to make an administration decision. Again, this is an improvement over Victoria. So here, effectively, the patient, more or less anyway, is going to have a choice as to whether to take the substance themselves, self-administration, or to ask a doctor, who would ordinarily be probably the coordinating practitioner, but it could be someone else, to administer the substance to them, which obviously could be done, it could be done by drinking a potion, it could be done intravenously. There might be some conditions in which a person can't swallow and so forth. But what the person has to do, the patient, is consult with the coordinating practitioner. You can't just say, I want to do it myself, or I want you to do it, doc. You have to have an interview, an assessment, discuss it, and reach a view together. The way I understand the Act is the doctor doesn't make the decision for you, but you have to take into account the doctor's view and make a decision. Okay, there has to be, if it's self-administration, there has to be a contact person, and the contact person has some obligations, because if it's self-administration, a prescription gets issued and the pharmacist is authorised to provide the substance, and either the person or a contact person or indeed an agent can go down to the pharmacy and collect the stuff. And it's what happens then is not quite as elaborate as in Victoria, where they have a lockbox requirement. There was a lot of discussion about that in the Melbourne conference on implementation last year that I went to, and discussions about someone in a nursing home or a hospital and the box is locked and it's under the bed or it's in the locker, and who's got the key and whether the key might be locked up somewhere else, and just went on and on. We don't have such an elaborate idea here. Nevertheless, it's obviously important that the contact person and indeed the patient themselves carefully look after the substance. Again, there were lots of discussions in the upper house of State Parliament about rather obscure hypothetical possibilities, involving someone in the home either getting the stuff and giving it to Auntie Mary when she wasn't ready, and how would you ever prove that the patient had taken it themselves, whether Auntie Mary took it herself or the no good Uncle Jack was the one who said, "Here, drink this, darling, you feel better." And other scenarios in which all sorts of people would commit suicide with this substance, all of which receives no support from 22 years experience in Oregon. It's just bizarre. Thank you again for coming, and we may see you again, hopefully at some more workshops.
Thank you.